Hi, welcome to Dream UPSC. Today we'll learn about Preamble of the Indian Constitution. Let's begin. To draft the Constitution of India, the Constituent Assembly members met on December 29, 1946. They concluded we need a first face for the Constitution. It should be like an identity. Simply it is an introductory statement which outlines the document's philosophy. On December 13, 1946, Sri Pandit Nehru stated we need our own constitution. He proposed an objectives resolutions.
While making the constitution, the makers thinks that we need to define the nature of the Indian policy and goals, objective of the Indian polity and governance. There are so many concerns in front of the makers, citizens' duties and their responsibilities. In case of emergency like financial war and invasion, remedies for fundamental rights. What is the supremacy of this constitution? Judiciary is safeguard of the constitution. What is its role in constitution? What are the emergency provisions? Based on this concerns and objective resolutions, makers noted major parameters to be justice in social, economical and political, equality of status in opportunities and before the law. Citizens should have freedom of their expression, belief of worship. These actions are subjected to public morality, to give safeguard the minorities and backward classes. We should have integrity of the territory of the Republic, sovereign rights over land, sea and air. We need to promote world peace and mankind. Finally, the preamble consists defining that we the people of India adopt, enact and give ourselves this constitution, and the nature of India is republic, democratic, secular and sovereign, and the goals are to provide justice, equality, freedom, integrity to all the citizens of India. India became independent on August 15, 1947. The date was set by the British. After adopting the Constitution on November 26, 1949, some of provisions are adopted like elections, citizenship and provisional parliament. The fully Constitution came into force on January 26, 1950, when Lahore session of Indian National Congress held in January 26, 1929. There the first resolution passed for Purna Swaraj. Next, on December 31, 1929, Sri J. L. Nehru hoisted tricolor on the banks of River Ravi. A public declaration was made on January 26, 1930, a day which the Congress Party urged Indians to celebrate as Independence Day.
We, the people of India, having solemnly resolved to constitute India into a sovereign democratic republic and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all, fraternity, assuring the dignity of the individual and the unity of the nation. Is the preamble just a preface of the Constitution? Is it not part of the Constitution? What is the importance of preamble in the Constitution? Let's have a look at on the major judgments on Constitution to know what is the philosophy of Constitution. The first significance was Barabari Case in 1960. Barabari is a village located in West Bengal. It is a land dispute between India and Pakistan. While partition, Sir Radcliffe was appointed as to partition the India, while partitioning the country, Muslim populated places separated from Punjab and West Bengal, it named as East Pakistan, present Pakistan, and West Pakistan, present Bangladesh. The boundaries of India and Pakistan were to be assessed by the award of a boundary commission chosen by the Governor-General. India and Pakistan did not accept the award that the Radcliffe Committee determined it to be. To resolve these boundary disputes, Indian Prime Minister Sri Jawaharlal Nehru and Prime Minister of Pakistan Mr. Feroz Khan Noon signed an agreement in 1958 known as Nunun Agreement. Nunun Agreement clearly stated that the territory of Barabari will be equally distributed between India and Pakistan, to transfer one half of the area of Barabari Union by India to Pakistan in exchange of Cooch Behar enclaves. Therefore, the President took the matter to the Supreme Court under Article 143. There were mainly two issues associated with the Barabari Union case. Firstly, whether the Parliament has the power to grant any territory of the state to a foreign country under Article 3 of the Indian Constitution. Secondly, whether legislative action is necessary for the implementation of the Nunun Agreement. The Supreme Court's judgment also mentioned that the preamble of the Constitution serves as a guide to open the minds of the makers of the law. The preamble of the Indian Constitution is not the source of all the powers given to the Indian government by the Constitution of India. In Jalandhar, Punjab, two brothers called Henry and William Gnath owned around 500 acres of farmland. The Gnath brothers were told that they could only have 30 acres of land under the newly adopted Punjab Security and Land Tenure Act, and that a portion of the land would be allocated to tenants while the rest would be considered excess and taken over by the government. The Gnath family contested the Punjab government's actions, and the case finally reached the Supreme Court in 1965. This was challenged by Gnath family under Article 32, Article 19, F, 19, G, Article 14 of the Constitution, mainly land reform acts aimed at an equal and uniform distribution of agricultural land so that concentration of ownership was not in few hands. Abolition of intermediaries of the medieval land ownership system in India, but our Constitution guarantees us fundamental rights, which include the rights of minorities and other underprivileged groups. Parliament and state legislatures in India have the right to establish laws within their respective domains, according to the Constitution. Fundamental rights are seen to be important for the growth of a person's individuality. These are the rights that enable a guy to plan his or her own life in the way that he or she desires. Finally, Supreme Court concluded that the fundamental rights can't abridged by the Parliament under Article 368. Parliament can't amend fundamental rights of the Constitution.
The next most significant case in Indian history was Sri Kesavananda Barathi case. It was a landmark decision of the Supreme Court of India that outlined the basic structure doctrine of the Indian Constitution. Kesavananda Barathi was the chief pontiff of the Ednir Mutt located in Kasaragod district, Kerala. The Kerala state government passed the Land Reforms Amendment Act in 1969. As per this act, the government could acquire some of the lands that belonged to the Mutt. In March 1970, Barathi moved the Supreme Court, under Section 32 of the Constitution, to enforce the rights that were guaranteed to him under Article 25, right to practice propagate religion, Article 26, right to manage religious affairs, Article 14, right to equality, Article 19, 1, F. Freedom to acquire property, Article 31, compulsory acquisition of property, and necessity to check whether the following is constitutionally valid, 24th Constitutional Amendment Act, 1971, 25th Constitutional Amendment Act, 1972. The extent to which the Parliament can exercise its power to amend the Constitution. In this case, for the first time, a bench of 13 judges was assembled to hear a writ petition up to 68 days, Kerala Land Reforms Act, 1963 amended in 1969 acquired land of Ednir Mutt for socio-economic obligation. 29th Constitutional Amendment put this 1963 law in 9th Schedule, filed petition under Article 32 for enforcement of Article 19, 1, F, right to property. Article 13, 2, states that no law can take away fundamental rights, but Article 368 states any provision can be amended by Parliament.
Any amendment of the Constitution by Parliament should not violate the fundamental rights. All these judgments are subjected to the preamble of the Constitution which is nature of the Indian Constitution. Fundamental rights are seen to be important for the growth of a person's individuality. These are the rights that enable a guy to plan his or her own life in the way that he or she desires. The landmark judgment was delivered on April 24, 1973 by a razor-thin majority of 7/6, wherein the majority held that any provision of the Indian Constitution can be amended by the Parliament to fulfill its socio-economic obligations that were guaranteed to the citizens as given in the Preamble. Supreme Court stated that, the basic structure doctrine states that the Parliament has limitless power to amend the Constitution subject to the condition that such amendments should not change the Constitution's basic structure. 42nd Amendment Act, 1976 is considered as one of the most remarkable amendments to the Constitution of India, 1950. This Amendment Act is often referred to as the mini-constitution as, it made a large number of amendments to the Constitution of India. This Amendment Act amended the Preamble to the Constitution, 40 articles, and the 7th Schedule, and added 14 new articles and 2 new parts to the Constitution of India. This Amendment Act introduced the necessary clauses to the Constitution of India that allowed for the suspension of fundamental rights in times of need, whenever an external emergency is imposed. Article 358 of the Constitution of India has the effect of suspending the rights given by Article 19 of the Constitution of India without any special notice. It provides that Article 19 is suspended nationwide for the duration of the emergency and that emergency laws are given legal immunity. The 42nd Amendment changed the description of India from a sovereign democratic republic to a sovereign, socialist secular democratic republic, and also changed the words unity of the nation to unity and integrity of the nation. We, the people of India, having solemnly resolved to constitute India into a sovereign socialist secular democratic republic and to secure to all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation.